submitted. We will issue a decision promptly. Thank you very much. Um, uh, Madam Clerk, would you please call the next case?
In re VanDamme, Armin Dirk VanDamme appearing pro se, Kelly Dove appearing for appellees.
All right, good morning. Mr. VanDamme, would you like to reserve any time for rebuttal?
Yes, I would like to reserve about 4 minutes if I could.
All right, and you'll have to keep track of the clock yourself, but I'll try to remind you. Please go ahead.
Thank you, Your Honor. May I please the court? My name is Armin Dirk VanDamme. English is my third language, and I appear as pro se. When I get stressed, I refer to my old language, German. So bear with me. This is a long, extended case since 2004.
And Mr. VanDamme, before you start, I'm sorry to interrupt you, but I just wanted to mention just up front that you do have two appeals here, but we're giving you 15 minutes to cover both of them. So I just wanted to make sure you were aware of that. Sorry for interrupting you. Please go ahead.
Thank you so much. Because Article 3 standing is jurisdictional and may be raised at any stage. Appellant, myself, respectfully request that the panel require counsel to identify and produce evidence of the real party in interest. Specifically, proof that US Bank NA and Wells Fargo Bank NA were entitled to enforce the note and deed of trust, now known to be held by Tiffany and Bosco, and is required under UCC 3-301. This appeal is about standing and jurisdiction and candor to the court. The declaration from Nicole Lane and ECF 25 submitted by Kelly Dove prove that Tiffany and Bosco, not US Bank and not Wells Fargo, has held the original promissory note and collateral loan file since 2019 until current. Tiffany and Bosco never appeared in this case, and Tiffany and Bosco is currently not represented by Kelly Dove. There's no proof that Tiffany and Bosco gave agency to US Bank or to Wells Fargo to enforce the note or the deed in trust. There's no assignment from Tiffany and Bosco to US Bank. There's no valid assignment from Bank of America to US Bank. Under UCC Section 3-301 and in reveal, the enforcing party must be the person entitled to enforce the note and must prove real authority from the holder. Under Edelstein, Nevada law requires reunification of the note and deed before foreclosure. This never happened in this case. Now, an important issue that I'm going to raise is the trustee substitution of NDSC, claimed to be assigned by US Bank, is a conflict created by Kelly Dove herself. In this case, before this panel, case number NV 22-1175, Kelly Dove claimed through Snell and Wilmer before this court that NDSC was assigned and TD Service Company was removed on December 3, 2004. This was to validate the 2007 and 2008 defaults and received an order from Judge Nagagawa in case number 21-01067, based on the concept that NDSC was assigned by US Bank to the case on December 3, 2004. Now, this created a big conflict because now, before this panel, Kelly Duff claims the removal occurred on November 19, 2013. This happened because in the previous case that I mentioned before this court, Kelly Duff did not file in their proof of claim the November 19, 2013 assignment to NDNC. Why did she not submit that? Because NDSC was assigned by Bank of America, which was a conflict with her claimed assignment of US Bank in 2010. So 3 years later, so they omitted that evidence in the proof of claim in my 2019 bankruptcy case. Now she is claiming that the removal occurred on November 19, 2013. Now this creates a big conflict because if NDSC was assigned in 2013, it could never foreclose in 2007 and 2008. And the TD Service Company is removed in 2013. Only TD Service could have filed a notice of default in 2007 and 2008. So this is fraud upon the court because Kelly Duff right now claims a different assignment. And that
Mr. VanDamme, let me apologize for interrupting you, but the issues in this case, or these two cases, are whether the bankruptcy court abused its discretion in dismissing the case, and whether or not, they abused its discretion in denying an extension of the automatic stay, right? Those are the issues. Please address those issues.
I will address those issues. Your Honor, my case was dismissed on March 13, 2025 at Judge Spraker. The automatic stay was still in place until March 13. Right after the trustee sale, and then I go to the heart of the issue, I filed a motion to vacate on February 24, 25 at 9:14 a.m. I drove after that. It was the day of the trustee sale. I drove after that. I drove to the trustee sale place in which the trustee sale was scooted up from 10 o'clock to 10:30. Then the 10:30 came along and the trustee sale still did not occur. So it was moved up to 11 o'clock. On 11 o'clock, the trustee sale was held. Looking at the docket later, Judge Spraker issued an order at 9:44, 60 minutes before the trustee sale was held. So there's ex parte communication between Snell and Wilmer and Judge Spraker, which is a conflict of interest. And furthermore, I filed my case on January 21st, 2025, and on January 22nd, 2025, US Bank filed a motion to dismiss. Now, US Bank is not the trustee and not the beneficiary because Kelly Duff declared that Tiffany and Bosco, through a declaration from Nicole Lane, which is the assistant of Kevin Soderstrom, who is an attorney for Tiffany and Bosco and represents US Bank. So why would the assistant of Kevin Soderstrom file a declaration? But she declares that Tiffany and Bosco holds the deed and note. So they had no authority to file a motion to dismiss the second day. Now, after the trustee sale, the day after the trustee sale, I was claimed to be a non-party. Well, under Sturgill, you cannot file an order or file claims against a non-party. I filed the bankruptcy claim because I am the only one that holds the obligation under my name. It was my assumption that I'm a full 100% responsible for that loan. Kelly Duff declares that I am a non-party in two cases. Case number A-24- 909044. I'm declared a non-party. I cannot litigate in this case. I have no rights. I cannot use my due process. In my federal case, I'm also declared a non-party. Now, if I'm a non-party, I cannot be held liable for a loan that was agreed upon in 2008. And then furthermore, my ex-wife, Geraldine VanDamme, was included in the bankruptcy estate who didn't file bankruptcy. We filed a divorce on August 5th, 2022, during my bankruptcy case from 2019. Kelly Dove didn't object to my divorce. US Bank didn't object to my divorce. And the loan was separated. She was never liable under the loan modification. Now, this liability lacks standing for US Bank and Wells Fargo to foreclose, because what Wells Fargo did, signed a loan modification with me as sole borrower and Wells Fargo Bank as lender. Now, I submitted ample evidence that on August 22nd, 2007, Aurora Loans was received the BNC mortgage. On September 15, 2008, Aurora Loans filed for bankruptcy under Lehman. US Bank never held the loan. US Bank is never assigned. Judge Spraker dismissed my case without a hearing. He scheduled my hearings for April 1st, 2025. He dismissed all my cases on February 24th, the day of the trustee sale, 60 minutes before the trustee sale. And then declaring me after the trustee sale a non-party. It violates my due process. And US Bank, by the declaration, and Kelly Dove herself in case number, in a related case.
Mr. VanDamme, I just want to let you know that you're approaching only 3 minutes left. So you may want.
I will remain my time.
Thank you. All right, Ms. Dove.
Thank you, Your Honors. Kelly Dove for Appellees. As Your Honors recognize, the issues that we're here about today are whether Judge Spraker abused his discretion in declining to extend the automatic stay and in dismissing Mr. VanDamme's bankruptcy while also imposing a 2-year bar. Appreciating that Mr. VanDamme is pro se, it is still the case that Mr. VanDamme has at no point in any of the briefing or argument actually addressed those issues or below. And I would note that Judge Spraker, I think, handled this case masterfully and gave Mr. VanDamme every opportunity to make his record and address the salient points. In particular, while Mr. VanDamme did not appear at the February 18th hearing on the stay extension, he did appear at a March 4th hearing that was extensive and in which Judge Spraker at numerous times tried to redirect Mr. VanDamme to address the issues that were relevant to his decisions, namely whether Mr. VanDamme could satisfy his burden to show that this bankruptcy was not filed in bad faith. Given Mr. VanDamme's extensive history of bankruptcy filings, no demonstrated ability to reorganize, no demonstrated ability to address this debt, no demonstration that this bankruptcy was filed for any purpose other than avoiding the foreclosure sale. And at each turn, Mr. VanDamme turned back to the same arguments you've been hearing today about assignments that happened many years ago, loan modification from almost 20 years ago, and notably, all of those issues have been adjudicated in many cases, including in the bankruptcy before Judge Nakagawa, which was affirmed before the BAP several years ago, and then in turn affirmed at the Ninth Circuit, during which Mr. VanDamme raised the same arguments he's raising today about myself, about the beneficiary, about the servicer. So there has been no identification of error by Judge Spraker. Notably, this is an abuse of discretion standard where Judge Spraker's findings, which I think have been careful and thorough, and I think the record demonstrates have given Mr. VanDamme every opportunity to make his record and every opportunity to raise these salient points. We've seen no hint of an abuse of discretion in Judge Spraker's rulings. And so I'd be happy to entertain questions from the panel, but otherwise we'll give back my time.
All right, thank you. Judge Neiman, Judge Corbett, any questions? Nope.
Thank you.
Thank you. All right, Mr. VanDamme, you've got about 3 minutes left.
Yes, I'd like to the panel to maybe inform me on who Kelly Duff is representing today.
You're here to make argument. So that's what we're doing today. We're not answering questions. You're making argument.
Okay. So my argument here is that the U.S. Bank is not assigned by Tiffany and Bosco. Tiffany and Bosco is the only company that can litigate this case. Now, I think there's a great deal of fraud in this case, because every single document that has been submitted, assignment is submitted by BNC, so-called, in 2008 to LaSalle Bank. This is impossible because Bank of America purchased LaSalle Bank in 2007, October 1st, 2007. LaSalle Bank then assigns Bank of America in 2009, which is impossible because Bank of America purchased LaSalle Bank on October 1st, 2007. Aurora Loan received all BNC mortgages. I submitted ample evidence, and I want this panel to take a judicial notice. Kelly Duff cannot litigate a claim that she has no authority to litigate. She has no standing, she has no jurisdiction, and this court has no subject matter jurisdiction to hear the case because Tiffany and Bosco is declared by Nicole Lane to hold the deed and note. Now, this was at the 11th hour because Kelly Duff submitted a motion, an opposition in a related case where she admits that Geraldine VanDamme has no obligation under the loan. And even she did not collect or even try to collect against Geraldine VanDamme. So now, if she is claiming that the deed is still in place and that Geraldine is still obligated under the deed, where's the agreement? Now, if the deed is still operative, then the deed and her obligation is extinguished by the operation of law. And that is under NRS 106-240. And it extinguished on January 10th, 2018, as NDSC filed a notice of default on January 10, 2008. That notice of default was never rescinded. So that default is still in effect, and she's not obligated under the loan modification. So it automatically extinguished on January 10, 2018. Geraldine has no obligation. Now, Judge Spraker...
Mr. VanDamme, your time is up. If you want to make one last statement to just conclude your argument, you can, but your time is up.
Judge Spraker presided over this case perfectly, like Kelly Duff says, but Judge Spraker included Geraldine's estate. By claiming I was not a non-party, he included a non-debtor's estate, which is prohibited.
All right. Thank you. Thank you very much. All right. This matter is submitted and we will issue a decision promptly. Thank you both very much.
Thank you.
Madam Clerk, would you like to call the last case?